Very good morning, everyone. And on behalf of LexisNexis, I would like to welcome all of you to the first QICDRC Lexis, 9th of March 2020. More than a year and a half later, after everything the world has been through, I'm happy to see a lot of familiar faces. As we all know, the QIC established a decade ago, covering the development of a world-class international financial center, backed by a court renowned while upholding international standards, while upholding the highest standards in this truth. The QICDRC is part of the strategy of the state of Qatar to attract international business and financial services to Qatar, whereby the QICDRC provides a modern, specialist civil court and commercial court to design the hear cases quickly. Economically, that's the oppose that, and the civil and commercial court designed to hear cases quickly, economically, and in front of an internationally renowned independent judges. So today's seminar will be shedding the light on the new jurisdiction of the Qatar International Court under Law 14 and 15 of 2021, amending the Free Zones law from 2009. To discuss the topic, we have representatives from both concerned entities. Hence, I would like to introduce our distinguished panel for today's session. Christopher Grout has been the Registrar of the QICDRC since its inception nearly a decade ago and gives procedural guidance on the parties about proceedings, as well as directions in relation to the progression and management of active cases. He is also part of the Court's Judicial Advisory Board. Furthermore, Chris is a barrister at 15 NBS Chambers, and in 2019, Christopher was appointed as a Deputy District Judge in England and Wales. From the QFZA, we have Davies, who has been part of the Qatar Free Zone for over 4 years and a half, as the Regulation Director, Senior Legal Counsel, and Interim Chief Legal Officer, prior to which he was responsible for the Healthcare Regulation Program and the Supreme Council of Health in the state of Qatar. Please welcome, ladies and gentlemen, with a warm applause, Christopher and you.
Welcome back again. Thank you for coming today. And thank you for wearing the mask. And please keep. I will let my the supervisor of security give them security moment regarding.
Good morning, all. I am Shiju, Supervisor Security. Your safety is our priority, and we would like to explain our safety features at the time of emergency. And if you hear any fire alarm, don't be panicked, and you will hear to the speaker that you need to evacuate the building by using the nearest safe exit. So our floor warden and safety officer and security personnel will direct you to the exit doors at the assembly point. And we place the signs and like evacuation plan near to the exit doors. And thank you for the trust. Have a good day. That's my cue.
So I'm instructed to be close to the microphone. So if I'm too loud, please let me know my booming Welsh voice. Good morning. My name is Davies, and I work, as you heard, in the Free Zone. The plan for this morning is I'll give a quick overview of the Free Zone. I will touch upon the amendments made recently, and then Chris will provide an overview of how the amendments will work from an operational perspective in the court. The Free Zone Authority is responsible for 2 free zones here in Qatar, Ras Bufontes, which is near the airport, and Amal Hul, which is near the seaport. As you can appreciate, Qatar's geographic position attracts numerous investment into the region because of its proximity to the Far East, in particular with Western companies, bearing in mind that over 60% of the world's population is within 8 hours flying time and 5 days sailing time. We also have 8 leading universities providing cutting-edge research, which again facilitates the interest in our investors in the free zone and in other investors in the mainland. Free zone itself is focused on logistics, emerging technology, chemicals, and manufacturing. We've attracted some of the bigger names in our 200 plus investors, such as Google, VW, Gasson, and Inventus Power. The World Cup obviously is providing an interesting platform to enable investors to be attracted into Qatar and the free zones. And we've seen, for example, VW and Yutong being located and investing in the free zone and providing, or plans to provide autonomous buses for the World Cup in the future. I'll just touch upon quickly on Ras Bufontas to give you an idea of its size. This is the key sector activities here, the logistics hub, the emerging technologies, light manufacturing, the aviation sector, given its proximity to the airport, and international business services. It's 4 square kilometers in size. And the second being a Malul, slightly larger, 30 square kilometers. This is aimed at the heavier industries, such as maritime industries, manufacturing industries, and also a degree of emerging technologies. What's quite interesting, I should say, and I'm doing my research on the free zones, is that we've got smart streets. Both enables the 5G technology to be rolled out, and also their strategic street alignment reduces urban heat, which in this day and age is quite popular and important for numerous free zone entities. Here's a quick overview of what we have on offer in the free zones. Primary importance is the 20-year tax holiday and 100% foreign ownership. Also, we look to partner and enable partnership with mainland businesses, and we also have our own investment fund at DVC, which has circa $1 billion US, which has invested quite heavily in international businesses, thus attracting them into the free zone and acting as a catalyst for other investors. Obviously, we need an advanced licensing regime, and we need a structured regulatory framework. Supporting the free zone is the enabling law, which you're well aware of, as well as 6 sets of regulations, being the licensing regulations, companies, collateral and security, land lease, building and permits, and the mandate and power regulations. All these are also supported by explanatory notes and frequently asked questions, again, to aid the investor and those advising the investor, being the professional advisors. More importantly, from now on in, we'll be subject to the Qatar International Court on two levels, both in relation to the licensing decisions we take, and also it's an opt-out provision. The default situation being that investors will be subject to the remit or the jurisdiction of the court in relation to any commercial activities, which I'll come to now. As I mentioned, the amending law has provided for 6 amendments, in essence. The first being a definition change of the free zone itself, so that the boundary requirement which used to exist has now been removed. You'll see that Article 25 has created the position of a managing director, which represents the board to ensure that the free zone on a day-to-day basis achieves the board's intentions and directions. And Article 41, equally as importantly, now states that the registered companies will be subject to mainland provisions, whereas previously they were treated as being an existing outside the mainland. We think of withholding tax and other such matters. This did cause some headaches and also impacted on the free zones entities when it came to their business plans. Article 18 is a new provision, and this allows the authority, upon the Council Minister's approval, to designate any of the buildings or facilities outside the 2 free zones, as they're known, to be administrative headquarters of registered companies in the free zones, yet again expanding the offering that is available. Equally as importantly, I think, are these 2 changes which Chris will be detailing. First being in Article 14. We have a licensing procedure which, if the free zone entities disagree with, they're able to appeal. The board's decision is now 30 days, far more specific than previously, which was a month. and equally importantly, the decision of the board and the Free Zone Authority is subject to the regulatory tribunal within the QFC. Also, from an Article 44, that has been amended and now enables the Civil and Commercial Court to deal with all civil and commercial matters between the registered companies in the free zone, the investors, authority and individuals and registered companies in the free zones, and registered companies and individuals residing in the state or companies or entities established outside the free zone, broadly mirroring what is already available for the QFC jurisdiction of the court. Also equally as important, I think I just draw attention to the fact that parties are still able to settle disputes by other means. So whilst the premise will be that the QICDRC has jurisdiction, it's still open to the parties to select another means of dispute. Chris, I'll hand over to you now so that you can explain how this will work procedurally within the court. Thank you.
Thank you, Hugh, and thank you everyone for coming. It's very difficult to make a presentation about the jurisdiction of the court, particularly interesting, but I'm going to do my best. And the way I'm going to do it is by having a look at some of the jurisprudence to date that has emanated from both the court and the regulatory tribunal in relation to jurisdictional matters that have arisen in the context of QFC-related disputes. And the reason that I suggest that that may be relevant is because, as Hugh has already alluded to, the intention of the new free zone law is to effectively mirror the provisions insofar as they relate currently to QFC disputes to QFZ disputes. So hopefully, when one looks through the jurisprudence of the court as it relates to jurisdictional matters, it will give you some indication as to how QFZ disputes, when they arise, will be dealt with by the court and the tribunal from a jurisdictional perspective. So the key starting point before we look at the free zones law is to look at the jurisdictional provisions as set out in the QFC law, because the QFC law, of course, provides the primary basis upon which the court and tribunal have jurisdiction to deal with disputes that come before it. And if we look at Article 8.3c of the QFC law, you can see from the slide that it sets out the various circumstances where the court will have jurisdiction to hear a civil and commercial dispute. Now, traditionally, we know that the types of dispute that the court will hear under subsection C1 is cases where both entities are established in the QFC. Under C2, we're looking at disputes that involve the QFC authorities or the institutions on the one hand, and those who are operating within the QFC on the other. Now, typically, that involves cases involving either the QFC authority, the QFC regulatory authority, or the Employment Standards Office. Then under C3, we have disputes involving entities established in the QFC and contractors of QFC companies, as well as employees. Now, in relation to contractors, and this is potentially important when one looks at the expanded jurisdiction under the Free Zone Authority law, the jurisprudence of the court has revealed that the term contractors is to be widely interpreted. And so you will note from the many cases that the court has heard to date that very often it's the case that you have a QFC party on one side and a non-QFC party on the other. And that's because the definition of contractor has been widely interpreted by the court to effectively mean any company or entity that is in a contractual relationship with the QFC firm. And then under C4, you have, of course, disputes with the QFC party on one side and a resident of the state or a company established in the state but outside the QFC on the other. Now, that was where the jurisdictional provisions of the QFC law traditionally ended, but in tandem with the Free Zone Authority law to which he was referred, there is now a new provision added, which is C5 on this slide, to say that the court will also have jurisdiction over civil and commercial disputes where any other law has assigned jurisdiction to it. Now, that's potentially important because in the context of today's discussion, we're simply talking about the amendments that have been made by the Free Zone Authority law. But of course, this broad provision that's been added as C5 will potentially allow in the future other laws to increase the court's jurisdiction further by electing the court where appropriate. the regulatory tribunal has a much more limited jurisdiction, as you will appreciate, and it only hears appeals raised by individuals and corporate bodies against decisions of the QFC institutions. But you will see that the amendment that's been made as a result of the new law is again to say that the regulatory tribunal's jurisdiction will be expanded to include any law that is passed subsequently to increase its jurisdiction over other entities. And Hugh's already alluded to the fact that under the Free Zone Authority law, it does just that. So turning then to the Free Zone Authority provisions, Article 14 and Article 44 are the important provisions for the purposes of the increased jurisdiction of the court. Now, Article 44, certainly as I read it, is fairly restrictive because the only jurisdiction it appears to be giving to the regulatory tribunal is to hear appeals relating to decisions to cancel or suspend the licenses of companies that are operating within the free zones. That's certainly how I read Article 14. But nevertheless, it gives the tribunal an increased jurisdiction from that which it has had hitherto. Now, Article 44, although it's not written in precisely the same way as Article 83C of the QFC law, I would agree with Hugh's observation that what it seems to be doing is to try and give the court jurisdiction in exactly the same way that the provisions of the QFC law do operate, albeit that the wording is slightly different. But it seems to me, certainly on my reading, that there's no significant distinction to be made between the QFC law's drafting and the way Article 44 of the Free Zone law is drafted. So I thought it would be helpful to next turn to some of the jurisdictional decisions that the court has made to try and give you some insight into how the court may interpret these new provisions under the Free Zone law. And the first, and it has to be said, one of the most common issues that the court faces is whether or not it is a Qatari court for the purposes of the QFC legislation, and indeed for the purposes of the state law. And we see from a case from last year by the name of Ican Richards and International Financial Services Qatar, that the issue that was before the court was whether or not a dispute resolution clause that simply referred to the Qatari courts as opposed to specifically the Qatar International Court or the QFC court was sufficient enough to fall within the jurisdiction of this particular court, or whether what the parties intended was in fact to go before the national domestic Qatari courts. And I shan't read that quote out, but you will see from the slide that what the court decided was that the Qatar International Court is clearly a Qatari court. It is established by state legislation. The regulations themselves of the court recognize that it is a Qatari court, and it is insufficient for a party to simply say that by reference to Qatari court in a dispute resolution contract, what the party is seeking to do is use the national courts. What the court was concerned with, especially in the context of a case that involved a QFC registered company, was that the important thing to do was to look at all the circumstances to determine what the intention of the parties was. And you will see from the quote on the slide that the court concluded that in this particular case, it was satisfied that by Qatari courts, the parties intended to come to the international court. And I would submit that there's no reason why that approach would be any different in the context of free zone related disputes. The other interesting point that arises from time to time is whether or not there is a requirement to opt in to the jurisdiction of the Qatar International Court, or whether instead the issue is one of opting out. And you will see from the jurisdictional provisions both of the QFC law and of the Qatar Free Zones law that the phrase that is used is that unless the parties agree otherwise. Hugh said that creates a presumption that this court will have jurisdiction, and I agree with that, and so did the court in this particular case, where a law firm was essentially suing a number of defendants in order to try and recover unpaid legal fees. And you'll see from the slide that the court rejected the argument advanced by the defendants that in order for the court to have jurisdiction, the parties must explicitly opt into it. The court said, no, if you fall within the jurisdiction provisions, then there's a presumption that the court will have the authority to hear the case unless you explicitly decide to opt out. And again, I would suggest to you that there's no reason to believe that the approach under the free zone law will be any different to the approach adopted to date by the court in respect of QFC disputes. Let's have a look briefly at some of the cases where the court has declined jurisdiction. The first is that in a recent case concerning a company called Amberberg Limited, the court found that where a company is not registered in the QFC, the mere fact that it is a sole shareholder of a QFC company is not sufficient to bring it within the jurisdiction of the court. So again, there's no reason I would suggest to find that there would be a distinction between QFZ related disputes and QFC related disputes. You need to be a QFZ entity in order to fall within the provisions. It would appear based on this authority that it's not enough for a company that's not established either in the QFC or the free zones to simply say, well, I have a 100% ownership of one of those companies, and so that should bring me within the jurisdictional provisions, because the court in that case took the view that that wasn't correct. Another instance, and this is quite an unfortunate case of Arab Jordan Investment Bank. This was a case where, although the defendant was and is established in the QFC, the claimant was bringing a case before the national domestic Qatari courts against a third-party company not registered in the QFC. And what he was asking the local domestic courts to do was effectively issue an order of disclosure against the QFC registered bank to assist him with his litigation against a third-party company. And the national courts took the view that they didn't have the jurisdiction, both at law and on the facts of the case, to order the third party, in this case the QFC registered bank, to provide disclosure. And so what happened is the claimant came to this court and said, oh, well, the bank is registered in the QFC, so you have the jurisdiction to issue an order requiring it to provide me with documents so that I can go back to the national courts, argue my case with the benefit of the documents from the bank. Now, the court had some considerable sympathy with his position, but what the court said was that is not enough to bring it within the jurisdiction of the court. Why? Because you don't have a civil or commercial dispute with this particular bank. Your dispute is with the third party. What you're trying to do is get assistance from this court to help you in that other litigation, which the court decided that based on a strict reading of the provisions that we looked at earlier, it simply didn't have the power to do. Now, the court reached that conclusion with some degree of reluctance because it recognized that it put this individual in a slightly unfortunate position in that he couldn't obtain the documents that he needed to fight his case. But again, the court felt constrained by the provisions that we've looked at. And then perhaps most obviously, where there is a clear jurisdiction clause pointing to somewhere else, the court will decline jurisdiction. So in the case on the slide there at point 3, that was a case where the clause clearly pointed to the English courts having jurisdiction over the dispute. And so the court had no trouble in declining jurisdiction on that basis. Finally, just very briefly on the jurisdiction of the regulatory tribunal, the only point that I think is of particular interest in the context of what we're discussing today is that of time limits, because as Hugh has already alluded to, there is a 60-day time limit contained within the free zone law in order to appeal a decision relating to the suspension or revocation of a license. Now, we have had some cases about the time limits in the regulatory tribunal, and the first time that this issue arose was in a case called Al-Tamimi against the Employment Standards Office and the QFBA. And the question for the tribunal was whether or not it had a power to extend the 60-day period that was set out in the QFC law, and now we see set out in the free zone law. Now, what the court concluded, or what the tribunal concluded, is that it had no power to do that because the time limit was set out in a primary piece of legislation, and there was no provision contained within that legislation to allow it to extend the time period. Now, I would suggest that because in the free zone position, as mentioned by Hugh, the period is also set out in the law, then it's likely that the tribunal would come to the same conclusion. So you've got to get your appeal in within the 60 days. Otherwise, you effectively lose your right to have the matter adjudicated by the tribunal. And that decision was upheld by the Appellate Division of the Court, and then later followed in a case earlier this year by the Regulatory Tribunal. It is right to say that the issue of time limits is currently under challenge again before the Appellate Division of the Court, so we need to watch this space to see whether or not the Appeal Court takes a different view as to how the issue of time limits should be treated. But as things stand at the moment, the position is no power to extend a deadline that is set out in the law. And I would say that in the Free Zones case, it's common sense that the same provision, the same interpretation will apply. So thank you very much.